arbitrationagreements.org. Welcome, and thank you for joining us as we delve into the basics of legal arbitration, a significant form of alternative dispute resolution, or ADR. Whether you are a legal professional, a business person, or simply an individual interested in learning more about this approach to settling disputes, we are sure you'll find value in this exploration. Now, before we get started, please like this video, press the subscribe button, and tap the bell for notifications so you can keep up with crucial dispute resolution topics that can save your business a great deal of time and money. At its core, legal arbitration is a procedure in which a dispute is submitted, by agreement of the parties involved, to one or more arbitrators who make a binding decision on the dispute. It's a private method of resolution chosen by the parties to avoid lengthy and expensive litigation in court. Now, you may be wondering what types of disputes can be arbitrated. The answer is almost any kind of dispute can be arbitrated, from commercial contracts, labor relations, to family matters, and more. The primary prerequisite is that parties must agree to resolve their dispute through arbitration. Arbitration is especially popular in commercial disputes. In fact, a recent study showed that over 97% of international commercial contracts contained an arbitration clause. That's a massive vote of confidence for this method of dispute resolution. In arbitration, the disputing parties give an arbitrator the power to decide the dispute. This arbitrator can be a single person, or it can be a panel of arbitrators. This arbitrator, or panel, listens to both sides, reviews evidence, and then makes a binding decision, often called an award. A key strength of arbitration is its flexibility. Parties can tailor the process to suit their specific needs. From choosing the arbitrator, determining the location, to selecting the applicable laws. This flexibility can help make the process faster and less formal than traditional court proceedings. But let's talk about the efficiency of arbitration. A 2018 study found that arbitration cases were resolved on average in less than 8 months, whereas traditional litigation can often last years. There's no question about it. Arbitration can be a powerful tool for resolving disputes quickly and effectively, while preserving relationships and maintaining confidentiality. Do you need more information about the basics of arbitration? If so, head on over to arbitrationagreements.org. That's where you can buy the service or program you need right away and begin the dispute resolution process quicker. Now, our association does not provide any legal advice, but give us a call if you or your business are considering opening a new account or case. In fact, countless companies and individuals utilize our services to handle claims in a controlled manner through cost-effective solutions. If you are interested in doing that as a business, we are standing by. Successful companies depend on arbitration to save money. You're paying one service per case instead of experiencing the uncontrolled expenses of a standard lawsuit. That's the key reason why arbitration is so popular. Also, what do you think about arbitration? Is there a specific advantage that stands out to you? Give us your opinion by leaving a comment below. Don't forget to like the video, hit the subscribe button, and ring the bell for notifications so you can stay up to date about alternative dispute resolution processes that can save you time and money.